Welcome to the Digital Planning Podcast. This series is designed to educate individuals about all things digital in connection with estate planning, business planning, and estate administration. To keep up with all things digital, please subscribe at iTunes, Stitcher, Google Play, or wherever you download your podcasts. And now, Jennifer Ziegel, a partner at Kleinbart LLC, Ross Bruck, a principal of Estate Genie, and Justin Brown, a partner at Pepper Hamilton LLP, with today's topic.
Welcome to the Digital Planning Podcast. I'm your co-host, Justin. I'm here with Ross and Jen, and we're going to do the third part of our three-part series on electronic wills. So today, we're going to continue our discussion from our prior two episodes, and we want to just go briefly through a review of the three types of electronic wills that we've been discussing. So the first one would be offline wills, and these are wills that are stored on an individual's computer or tablet or smartphone and have no connection to the internet whatsoever. The second type of will is an online will, which is a will that would be stored on some type of electronic medium which is on the internet. So, for example, somebody posts a document to their cloud account, or it's stored in Dropbox or Facebook or Evernote, something like that, where it now subjects the document to the terms of service agreement of the medium that is holding it. And the third one would be custodian wills. These would be wills that a third party is hired by the testator to create a will, and this third party is then storing the will on their own specific medium, which also is going to be subject to terms of service agreements. Now, as we talked about last time, there are many public policy issues associated with electronic wills. There are issues that need to be dealt with regarding fraud, undue influence, authentication of documents. But today, the focus of our episode is going to be on the public policy argument regarding storage of electronic wills. And the storage of electronic wills is a huge issue that is impacting how electronic will legislation is crafted.
And right now, there is no uniform treatment of electronic wills, and many states have very different jurisdictionally specific requirements for document execution and various other types of statutes that could or could not allow digital wills to be admitted to probate at this point in time.
Every format of electronic will, both the online, offline, and online with qualified custodian, has its individual problems, and storage is a big issue. For the offline will, storage becomes an issue because wherever that will was drafted could disappear, could be stolen, could be destroyed, along with it all the contents within it.
I'm sure we've all had experiences where we thought we saved a document and can't seem to locate it at all.
So I think we see a lot of flaws with the offline medium. The next category of online, well, equally problematic. If I were to draft a document and store it on a digital storage platform, and that platform goes out of business, I may no longer have access to that document. And no one may know until after my death that where I created the document is no longer accessible. And in all likelihood, that third-party provider doesn't have any obligation to store that will indefinitely or to send it to another platform for the testator's future use.
Or what if there's a security breach with that third party or the online medium? Again, to your point, there's probably no duty to indicate to the testator that their website has been hacked and their will may be gone, or they may have put sensitive information inside of their will, which is now available to whoever has access to the information.
So that brings us to the third category of a qualified custodian. And what are some of the things that we'd want to see a third-party provider be required to offer when talking with a potential testator? It's a guaranteed format to transfer any documents that if that provider is going to go out of business, they must send it to the testator or to another third-party provider. In the non-digital world, if a law firm, at least in Pennsylvania, is going out of business and winding down, there is a legal duty on behalf of the attorneys to transfer the wills in their will vaults to another law firm or to the testator. Should there be something similar for a qualified custodian?
In Pennsylvania, under our current laws, although there are ethical violations, potential civil and criminal sanctions if those provisions are not followed, I personally have come across clients in my practice that had wills or thought they had wills stored with an attorney at a firm that went defunct and have not been able to ever find the original or get in touch with the attorney who drafted the original to see where it resides. So even today, there can be issues with storage of certain documents. I think there are less risk, but with an online type of digital custodian, that type of risk is magnified.
What if, in order to become a qualified custodian, that third party has to first register with the local probate office to alert them that they are providing this service to county residents? Number two, has to alert consumers that they're providing the service for notice of exactly what the law is regarding electronic wills. And in order for them to be able to provide a self-proving will, also register anything drafted on their platform with the county office. So, I know that there's a tremendous cost associated with that, but I actually think that a local probate office might be in favor of this for multiple reasons. One, as long as those registered documents come with a fee of some sort, it could pay for that management system. Two, it can act as a backup system if that provider ever goes out of business. Three, it gives the county an opportunity to have a better understanding of what transactions are currently occurring regarding electronic wills in their jurisdiction. To audit them, should that be necessary, to have an understanding of exactly what is being offered to consumers and the formats being offered in. And I'm not saying that would prohibit all other electronic wills, but what about those three ideas of registration, storage, and providing of the documents to be stored with the county as a minimum requirement for a will to be a self-proving will within a local jurisdiction?
I think that's a really interesting concept. Specifically in Pennsylvania, each county can have separate local rules, so I could see some tensions with establishing this type of system, particularly in Pennsylvania when each county has the ability in certain circumstances to deviate from some of the rules of the state and impart their own local rules. So I think we would have to figure out a way to overcome that tension. Now, other states, it might be more uniform and that could not be as much of an issue. So maybe it should be at a state level and not a county level.
Really, what I'm trying to solve with that idea is a little bit less of the outliers who are doing their own thing and providing their own services to consumer with little to no oversight because of the world we live in where the laws on the books have not caught up with the electronic modern age.
So I think, Ross, your proposal is a good one. But I think the greatest impediment is cost. And who is going to pay for states or counties to implement this type of system? And how do these counties create the system? How do they create a secure system? What is the cost associated not only with creating the system, but for the testator to store? And what would the cost be if the testator wants to amend or revoke the will and take it off the books, so to speak, of the local county? So I think the theory is good. It's, as with many things, it's how do you find the money to do it?
I'm a big believer in how free markets can solve that problem. Right now, you have third-party providers who are out there offering free estate planning drafting software of no charge. And there's upsells in other things that they do, and there's certainly ways that they're going to try to or plan to make money. To specifically address this, I think it's as simple as that third-party provider could offer an electronic will that is registered with a county office for an increased fee, or a lower cost option of a printed document that they're going to sign in person and take to their own notary for a lower cost. I think that that's a premium that the person, the testator who is interested in convenience and interested in doing everything electronically, may be willing to pay more, and that fee could both go to the third-party provider for their added services, as well as to help pay for this platform that is offered by the county. Now, I will certainly argue that that is limiting in itself, because you are excluding some individuals of lower economic means from equal access to this platform, and maybe there is a nonprofit solution around that could be integrated in part of this entire platform.
Well, and it only works with the third-party companies who are creating the wills and storing the wills, right? What about the people who are creating the wills on their smartphone or on their computers? Or how do you address? I don't know that you can't address everybody.
Or what about digital wills that are prepared by an attorney and just executed digitally? Would there be options for attorneys to help upload those documents to this type of database and assist with fees?
I think so. To both points, I think with regards to attorneys using that platform, that could either be part of their hourly billing or their flat fee billing, or it could be an upcharge for themselves that they themselves offer to their clients. And as for Justin's point about people doing their own documents, no, it's not going to solve that. That is always going to be a problem. But I think if it's more prevalent that third parties are out there offering their services, it will create an awareness about electronic wills and about proper execution of them above what we have today. And perfect, in this case, can be the enemy of good, because it's not going to solve every single problem out there, but it can address some of the concerns that a lot of the legal community have about electronic wills by having a stricter registration process for the parties who are going to offer these services.
One of the issues with electronic wills that we haven't touched on yet is the ability for electronic wills to potentially disrupt an estate plan. Because if you go to one of these third-party providers and they create your will, it's probably a computer program. It's probably some kind of AI creation that is going to you're going to answer a bunch of questions and it'll spit out a will. But it's not going to address all of the issues that you have in an estate plan. And I think as an estate's attorney, somebody who drafts wills, that's one of the issues that I have with these programs is that, yeah, they may draft a will, but it's an incomplete picture. It just addresses the will, not the non-probate assets. It doesn't address the spendthrift child or the child with special needs or any of the issues that we as estates attorneys run into every day with our clients, which is a good amount of counseling our clients.
And, to piggyback on that, in addition to the issues that you've just highlighted, with respect to a service by a third party for profit that is storing the wills, absent some larger governmental or county level structure to be tied to that, how is the testator going to communicate that the document is with the third-party provider? Traditionally, even if a will is not found amongst a testator's belongings, there could be some indication or a known relationship with an attorney that the loved ones could then contact the attorney, and potentially that person has the estate planning documents. But here, how are the loved ones going to be notified that the document has been created?
I actually think that an electronic format can address both of those issues a little bit better than the format we have today. Regarding the issue of non-probate assets, most estate planning attorneys run into that issue right now, and in their clients, testators, taking actions that that the attorney is not aware of regarding non-probate assets, and failing to provide that information and allowing the attorney to properly fit that into the overall estate plan. It might heighten that problem, but it doesn't create a brand new problem. And to that end, there's currently online estate document drafting software that is available to the public, not in an electronic will format. Again, it's that electronic signature that's lacking, but you can go on your third-party provider today, create your will, never talk to an attorney. The non-probate aspect of getting the proper guidance in terms of every other outside issue that you just brought up still exists today. And I think that as the world of electronic drafting and third-party providers evolves, hopefully they get smarter about asking about those non-probate assets and outside situations that need to be addressed. And Jen, as to your point, let's go back to one of our earlier episodes and talk about online tools, because I think an online tool could help solve that problem of notification. Hopefully, a good trusted estates attorney is knowledgeable about when one of their clients passes and takes the necessary steps to help notify parties that need that information. Well, electronic providers of wills could also follow a similar format that we talked about with regards to Google's online tool, that periodically the testator needs to acknowledge that they are still living, and upon a failure to do so after a certain period of time, the required either beneficiaries or fiduciaries are notified of that person's death, and it's a good format to then make sure that digital will gets into the necessary hands.
One of your risks being that the company goes out of business and there is no online tool available because the company's no longer in existence, in which case you've got the will stored with the Register of Wills or the surrogate or whatever it's called in the local county, and there would have to be some kind of backup communication mechanism on the county level so that they could learn when somebody dies.
That poses a couple other problems with these third-party providers. So you have the situation where they may require a user to actively go online or open their account or take some type of action to verify that they're still in existence. But what if somebody is using that person's computer and continuing to have those types of notifications to avoid the document from being disseminated? Or in the situation that the testator might be in a hospital due to, a debilitating illness and can't go online and open the account? Or what if there's an internet blackout or some type of natural disaster like in Puerto Rico, and there is an online service for a significant period of time? And because there is no online available services, the person can't, go through the requisite protocols to establish that they're still alive, and then the information, after a period of time gets disseminated. Would this be a breach of fiduciary duties because the person's still alive and they didn't give their consent? Other startups I've seen take a different approach, and they may actively search the internet, on a weekly basis for obituary notices or other types of death notices, and then at that point would disseminate information. And in that vein, I think there could be a lot of issues because many people have similar names, or they might only have one initial different. And if it's a computer system or a human that's trying to verify whether someone's still alive or not, there's going to be issues that arise.
All excellent points. And I'd argue that no new legislation around electronic wills is going to be perfect and solve for every problem, and it might create problems. But I'd also argue that today's system also has flaws. And as the world marches towards more and more use of electronic medium for every aspect of their daily lives, it needs to be addressed. And those are all things that need to be considered in future legislation. I hope that the people who are considering how to redraft the laws think about things like that, but don't use them as an excuse to completely avoid any evolution of the law.
No, I completely agree. It's a subject that we can't ignore. And in the future, I mean, we could be 5, 10, 15 years down the line, as digital wills evolve, I think there is a great chance that blockchain technology could be utilized in terms of a document management and transfer system in connection with digital wills.
A tool like blockchain can be very useful, and in our future episodes, we're going to explore what blockchain is, how it works, and how it might come into play in the planning world.
So thank you so much for joining us today as we finished our series on exploring digital wills. There's a lot more interesting topics and guests that are going to be coming on our show, and we hope you stay tuned.
Thank you for listening to this episode of the Digital Planning Podcast, the podcast designed to educate individuals about all things digital in connection with estate planning, business planning, and estate administration. Please subscribe to this podcast and leave us a rating or review at iTunes, Stitcher, Google Play, or wherever you download your podcasts. Thanks for joining us. We'll see you next time.